Number five, this is kind of various things under CISPA. So it's actually three subcategories, if you will. So the Child Status Protection Act, you're already familiar with it. It's when someone's part of a dependent or derivative, a younger person under 21, and the age goes over 21. It's a process to keep him as part of the case, even though they've been out, they aged out, if you will. Well, first thing is, I had a consultation, and usually when I have these consultations, more often than not, the people aged out, and when we do the SISMA calculation, doesn't work. This one, I did the calculation with the information they sent me at first. I was really happy to report to them that even though the kids were like 28 and 32, the other one 30 took so long that they were still part of the case. They just needed to pay the fee, and they were locked in. And as soon as the visa bulletin was going to get current in a while, within the time, so it would work out. But then after talking with them, they're like, "Oh yeah, by the way," I'm like, "Okay, as long as you're, CISPA qualified or 21 and unmarried." They're like, "No, no, no, we're married." I was like, "Oh my god, you can't be unmarried child. That's not going to work." So I asked ChatGPT, I'm like, "Is that the rule that you can't be unmarried? Could they just get divorced instead?" And ChatGPT is like, "No, you can't get divorced. That's not possible." And I was like, "This goes to actually a theme we have every week of something ChatGPT told me that's wrong." So this is this August 11th version of it. But then I studied and looked, and I found the FAM. It says 9 FAM 502.1-1D6, impact of marriage or divorce on CISPA. And I'll read the law. It's kind of cold, but let's do it. It says, while the CSPA CISPA may prevent the applicant's age from changing, the applicant must still meet the other criteria for child status, being unmarried. If the applicant marries, the applicant will lose child status, even though the applicant's age for information purposes may be under 21 for CISPA. A divorce, this is the part, a divorce that occurs after the child's 21st birthday and after the visa becomes available will not restore the child status because the applicant was married when a visa was available. In this consult, I had a visa wasn't available yet. It's like 6 months behind, but they had like 2.5 years for it to move forward. So it's probably going to happen if they get divorced in time, according to this. However, if the applicant divorces before the visa becomes available to the applicant as either the principal applicant or the derivative applicant, then the divorce may restore the applicant to child status if the applicant assists by ages under 21. It's like, oh, that's pretty magical. ChatGPT got it wrong, usual, but that's pretty cool. But now it's like, so they have to get divorced, and is USCIS got a problem saying this divorce is happening just for Child Status Protection Act? The regulations loud. Why would the FAM say it? I mean, that's intentionally says you play this game. But my also side worry is like, what if they get divorced? Okay, they even get the green card, and then they turn around and get married. Is that going to be a problem for USCIS not accepting the marriage and stuff? I don't have an answer. I haven't been able to find it. Someone posted on a Facebook group I posted that they'll consider that like a sham divorce or something. But why would it be? It's just a technical, strategic thing to do. Divorce is divorce if the court recognizes there's no sham. So I'm like, as a client, say, like, are you down to get divorced for this? Because I spend more time doing research on this, but I got to stop right now because I haven't been able to find the answer. I thought it would be easier to find it, but I'm going to pause it and see if they want to have more consults to figure this out. But if they're not going to get divorced, if their wives aren't down with it, then there's no point. But I want to share that with you. It's kind of crazy situation.